Welcome everybody to our continuing Honor the Professor lecture series. This is a series that, as you all know, Dr. Ross has put in place to honor our professors. We have a lot of really strong intellectual minds on this campus, and it is always a good thing when we can learn from them and bring them into focus through what they can tell us. And so today, this is kind of fun for me because the gentleman I will be introducing is my boss for 2 quarters out of the year as I come in and teach a class in his department. So he doesn't yell at me very often, and he's pretty calm when it comes to that, but it's still a privilege for me to be able to introduce him. I've known Keith for about 5 years, and we've enjoyed several discussions on business, finance, economics, all of my favorite topics. So it's been a lot of fun. Keith received his BS in Business Management and his JD from the University of Montana, and he also received his MBA from Gonzaga. He was engaged in private practice of law in Polson when he came to teach at SKC in the entrepreneurship department. That was back in 1999, so a couple of years ago. Not forever ago, just a couple of years ago. And he currently is the head of the business department, teaching a variety of courses. Since 2003, he has also been an adjunct professor at Gonzaga University. So without any further ado, I would like to introduce to you Keith Rennie, Director of the Business Department.
Thank you. This working? Good. Well, I appreciate the opportunity to speak here, and I really appreciate you guys all coming too, because I mean, we waited a long time for spring, and it finally gets here, and I feel that we have a really short window of opportunity to enjoy it. I've been privileged to be able to see quite a few of the presentations in this series, and I've been impressed. They've been interesting, informative, and I hope I can continue in that tradition today. I do want to talk a little bit about why I chose the topic that I did. In the time that I've been here at Salish Kootenai College, I've had the opportunity to meet with and talk to professors and instructors from other institutions of all kinds throughout the United States, Canada. And I'm always surprised at the lack of knowledge of what life is like on reservations. Even some of the institutions that you would think should know better, with Indian country in their back door, and opportunities for their students to pursue, yet they spend no time in talking about the things that are important to living and working, doing business in Indian country. They have international business programs, entertainment business programs, and they're much more interested in producing students that much better prepared to do business in China than they are in Pablo, or better prepared to do business in Los Angeles than in Browning. And I wanted to pick a subject that would illustrate some of the uniqueness of what it means to live and work and do business in Indian country. And as instructors, we face that all the time. We have cultural and learning style differences in our classrooms that we try to accommodate. We adjust the way we present information. But more than that, there's a lot of areas where the content is very specific to reservation life And one of the things I wanted to do was to pick a subject that would illustrate some of the unique aspects of how we live, how we do business in Indian country. And I think that nowhere is that more apparent than in the legal environment that we work in. The second reason I wanted to pick this topic is because I love teaching law. I like the freedom that it gives me and the ability to challenge students, to think about their attitudes, to think critically about their beliefs on how the law should operate. So I like them to think about, if they're going to extend the right of free speech to a Native activist, will they also extend that right to a leader of the Aryan Brotherhood? Or will they only extend the right of free speech to that speech that they agree with and not extend it to opinions that they find repugnant? And in doing this, I tend to use outrageous examples. And I tend to ask questions to try to force my students to think critically. And so no good legal presentation would be adequate without some kind of disclaimer. And this is mine. Some of the questions that I ask or the examples I come up with doesn't mean that I'm a neo-Nazi. Although I have had students accuse me of holding very strong political beliefs that I don't hold. And it's only because I try to use outrageous examples. So as a recovering attorney, I think it's my obligation to advise you that having presented you with my disclaimer, I'm free to do and say whatever I want in whatever manner I feel fit, and to exercise my rights of free speech however I choose. So I chose to talk about civil rights and its application in Indian country, not because it is the only reason that life is unique where we live, but because I think it illustrates one of the small differences about life here. I went to school for a long time. I graduated from 8th grade in Dixon, from high school in Polson, from the University of Montana Business School, and it wasn't until I got to law school that I realized that there really is no such thing as a constitutional right to free speech. It simply doesn't exist. For those of you who don't recognize it, this is the First Amendment to the Constitution. This is where most people believe that the constitutional right of free speech exists. But as you can see, it doesn't say that at all. It doesn't grant me the right to exercise free speech in any way. What it says is that Congress shall make no law abridging the freedom of speech or of religion, or the right to peaceably assemble, petition the government, and so forth. It's not a constitutional grant of rights. It's a restriction on federal government power. It's not a restriction on state power. Nothing in this amendment prohibits the state of Montana from outlawing the practice of Catholicism. After the Civil War, during the Reconstruction era, 3 Reconstruction amendments were passed, the 13th, 14th, and 15th Amendment. The 14th Amendment applies the 1st through 10th Amendment to the states. So just like the federal government is restricted from making laws that would interfere with my right of free speech, so is the state of Montana. Nothing in the Constitution prohibits private action. That is, Microsoft, Google, all those other big companies are not restricted by the First Amendment in terms of taking actions or instituting policies that would restrict a person's right of free speech. This only applies to federal power and to state power. Well, what about tribal governments? Do tribal governments have the right, or is there a restriction on tribal government power that prohibits them from passing an ordinance that would restrict the right to free exercise of religion? That is, can the Crow tribe pass an ordinance that prohibits the practice of Islam on the Crow reservation? Is that constitutionally prohibited? Well, it actually turns out that several courts have asked this question. And the, excuse me. The case I like to cite, because the language in it is very clear, is this case. In this case, the Navajo tribe had passed an ordinance prohibiting the transportation, possession, use of peyote on the Navajo reservation. The Native American Church uses peyote as part of their rituals and brought an action against the Navajo tribe claiming that this was an unconstitutional abridgment and their free exercise of religion. In this case, the 10th Circuit Court of Appeals looked at the First Amendment, First, Fourth, and Fifth Amendment actually, and said, no, this is not a restriction on tribal government action, and maybe this ordinance inhibits the right to the free practice of religion, maybe it doesn't, but it doesn't really matter because those constitutional restrictions in the Bill of Rights don't apply to tribal governments. That's not what they do. They apply to federal government and they apply to state governments through the 14th Amendment, but not to tribal governments. This case was in 1959. There were several other cases like that, faced the same kind of issue, all coming to the same conclusion, that there's no such constitutional restriction. So in 1968, Congress passed, and the Civil Rights Act was passed in 1964, so this was part of the same era. Congress passed the what's called the Indian Civil Rights Act. And the Indian Civil Rights Act is an act that says that tribal governments, in their exercise of self-governing powers, shall make no ordinance or pass no law that interferes with the right of free speech, free exercise of religion, denies due process, goes through all of those restrictions that are contained in the first 10 amendments to the Constitution, and places a prohibition on tribal government action in their ability to pass those laws. It also contains a provision that says that the right of habeas corpus will never be denied to somebody under this act. A writ of habeas corpus is the cause of action that you would have if you were incarcerated. It's used to test the legitimacy of somebody being held against their will. So that was in 1968 that this was passed. The Supreme Court had the opportunity to review the Indian Civil Rights Act. In this case is Santa Clara Pueblo versus Martinez. The Santa Clara Pueblo at this time had a ordinance, a membership ordinance, that said if your father's a member of the tribe, but your mother is not, that's no problem. The children are eligible for membership in the tribe. But if your mother's a member of the tribe and your father is not, then the children are not eligible for the tribe, for membership in the tribe. And Mrs. Martinez, on behalf of her daughter, brought an action under the Indian Civil Rights Act, claiming that that ordinance denies equal protection, and it's gender biased, and it's a violation of the Indian Civil Rights Act. And so she sued the Santa Clara Pueblo tribe in federal court. The case went up to the United States Supreme Court. The United States Supreme Court looked at it, and they looked at the Indian Civil Rights Act and came to the conclusion that the Indian Civil Rights Act contains no remedies except the writ of habeas corpus. That is, if Martinez had been incarcerated, then she would have the right to complain. But since there's nobody in jail in this case, there's no incarceration going on, there's no right to appeal to the U.S. Supreme Court. There's no right to go to federal court. There's no remedy afforded under the Indian Civil Rights Act. So this decision took a lot of teeth out of the Indian Civil Rights Act. There are scholars that would argue that the real benefit of the Indian Civil Rights Act is in tribal courts. That is, that Mrs. Martinez could have gone to tribal court to get relief under the Indian Civil Rights Act. The problem with that is that it puts the tribal court judge in a very difficult position. On the one hand, they have a tribal ordinance that's been passed by council, perhaps voted on by the people, that says this is what we want. And then on the other hand, they have this piece of legislation from Washington, D.C. saying you should do this. And the tribal courts have enforced the Indian Civil Rights Act with mixed results. Although since most tribal courts don't report their decisions, it's really hard to get any sort of good information on that. So I put this in here just for Professor Dolson's benefit. If you saw Professor Dolson speak, he talked about the 3 cases decided by Judge John Marshall, commonly referred to as the Marshall Trilogy. I went and watched Walter Echohawk talk the other day. He has written a book called that has a subtitle of The 10 Worst Indian Law Decisions Ever Decided. 2 of the Johnson Trilogy are included in that list of 10 worst cases. And this is all that Justice John Marshall had to go on in deciding those cases. So this is from a part of the Constitution, I talked about the First Amendment earlier. That's a limitation on federal power. This is the part of the Constitution where states are saying, we're giving up these powers and we're giving them to the federal government. This is the list of powers that we're giving to Congress: the power to make war, to raise an army, to print money, to run a post office, and to regulate commerce with foreign nations and among the several states and with Indian tribes. It's the only place in the Constitution where Indian tribes are mentioned. There's another mention of individual Indians in the Constitution. When I was in law school, I took a semester course in constitutional law, 15, 16 weeks. 5 weeks were spent on this part of the Constitution. And during none of that time did we talk about Indian tribes. And very, very little of that time did we talk about commerce with foreign nations. This portion of the Constitution has been twisted and turned and expanded so much as to be, I'm sure, completely unrecognizable to our founding fathers. The reason I bring this up is two reasons. First of all, when the Civil Rights Act was passed, Congress had to find some power in the Constitution that gave them the authority to tell a private business that they could not discriminate based on race. They had to get some power, they had to find some place that the states gave the federal government the authority to restrict private action in their employment, in their service to the general public, and so forth. And this is the basis of that. So this is, and it's not only the basis of the Civil Rights Act, but it's the argument in favor of the, it's the exact same debate that we're having now over the Affordable Care Act, commonly called Obamacare, and the justification of where Congress gets the authority to impose burdens on individuals who may have nothing to do with interstate commerce whatsoever. So the Civil Rights Act was passed, of course. It was tested, went to the U.S. Supreme Court. The U.S. Supreme Court found it was justified under the Commerce Clause of the Constitution. The first thing that you need to know about discrimination is that discrimination happens all the time, and it's not bad. We discriminate all the time. I try to be a discriminating consumer. I try to make informed decisions, one over the other. As an instructor, I discriminate in favor of those students who read their assignments and turn their papers in on time. Those students who participate in class, they get favorable treatment. They get better grades. We discriminate all the time. It's something that we do. It's only that there's good reasons to discriminate and there's bad reasons to discriminate. And there's 5 bad reasons to discriminate under the Civil Rights Act: race, color, religion, sex, and national origin. I always feel like George Carlin when I rip those off. Instead of the 7 words you can't say on television, it's the 5 reasons you can't discriminate. Presumably, everything else is fine. We can discriminate because somebody is overweight. That doesn't fall into one of these protected classes under the Civil Rights Act. I can refuse to hire cat people because I'm a dog person. That's not prohibited. It might be unfair, and it might be a really poor business decision, but it's not a violation of the Civil Rights Act, unless the discrimination is based on race, color, religion, sex, or national origin. Those are the prohibited reasons to to discriminate. There are a lot of exemptions under the Civil Rights Act. I teach at Gonzaga University, a Jesuit institution. While they let me teach business law, they would never let me teach theology. I may know the subject, and I may be a good theology teacher, but they want a Catholic teaching theology at Gonzaga University. And they're free to do that. So there's exemptions for religious organizations, for other types of organizations that serve particular populations. And there's also a universal exemption for tribal governments. Tribal governments, at least under Title VII. I'm most familiar with Title VII of the Civil Rights Act because that's the part that deals with employment. But the protected classes are the same for all of them. Tribal governments are exempt. They're defined out of who an employer is. So it says, employer under this act means such and such and such, but it does not mean tribal governments. So tribal governments do not have to comply with the Civil Rights Act of 1964. Incidentally, the Americans with Disabilities Act refers to the Civil Rights Act in terms of who's covered and who's not. So if you're not an employer under the Civil Rights Act, you're not an employer under the Americans with Disabilities Act either. So that means that tribal governments are not required to abide by the mandates of the Americans with Disabilities Act either. So, one of those questions. Who or what is a tribal government under the Civil Rights Act? Is Salish Kootenai College tribal government? Salish Kootenai College is a separately organized organization. It has a corporate charter, has a board of directors. As it happens, our board of directors is appointed by the tribal council. Does that make Salish Kootenai College a tribal government under the Civil Rights Act? Does Salish Kootenai College have to abide by the Civil Rights Act, or are they a tribal government such that they do not have to follow the mandates of the Americans with Disabilities Act? We just had a signing here, big ceremony, a lot of suits sitting around a table, television. One of the speakers there was from a company called Terra Ecos. Now, Terra Ecos is a company that's located in Missoula. It is owned. It's a corporation. The majority of the shares, perhaps all of the shares, are owned by another corporation. That corporation is SK Technologies. SK Technologies is a corporation that has one shareholder. That shareholder is the tribal government. Is Terra Ecos a tribal government under the Civil Rights Act? Does Terra Ecos have to abide by the Americans with Disabilities Act? This is a business located in Missoula. The question is, does that fall under the definition of a tribal government? I'm a member of a tribe from Oklahoma, the Citizen Potawatomi. They've been very assertive in economic development. One of the things they've done is to buy a radio station. It's a pre-existing business in Shawnee, Oklahoma. Did that turn it from a private business that could not discriminate based on race overnight into a tribal government that could then go in and fire all the Hispanics that might be working for it. Did that change it? And well, I'm good at asking questions. I'm really poor at answering them, because these questions still need to be decided. How far does this exemption go? And it does actually raise another issue about life here and how it's different on here than it would be other places. Outside of Indian country, you would very, very seldom see a government directly engaged in private business. But that's fairly common in Indian country, at least today. So these are questions that have yet to be decided. Under the Civil Rights Act and the Americans with Disabilities Act. So I have two more cases I want to talk about. The first is Morton versus Mancarey. Morton versus Mancarey. Stuart Morton was the Secretary of Interior. Mancarey was an employee of the Bureau of Indian Affairs. This was during a time that the Bureau of Indian Affairs was enforcing tribal preference. Doesn't deal directly with the Civil Rights Act, because the Civil Rights Act exempts federal government, but there was a similar act that put these restrictions on all government agencies, all federal government agencies. And Mancarey brought an action. Mancarey was passed over for promotion. And if you know federal government systems, they were very straightforward. Eligibility for promotion and ranking system. And they went outside that system and passed over Mr. Mancarey in favor, who was a non-Indian, in favor of a tribal member. And Mancarey brought an action against the Department of Interior, claiming that this was a violation of the equivalent of the Civil Rights Act, and that this was a racial classification. It favored members of one race over another, and as such, it was prohibited. This went all the way to the U.S. Supreme Court, and the U.S. Supreme Court, in what I think is a very interesting decision, says membership in a federally recognized tribe is not a racial classification. They said it's a political classification. It's a member of a political body, not a racial classification. And since it's not a racial classification, discrimination in favor of a member of a federally recognized tribe doesn't fall under the 5 protected classes under the Civil Rights Act. And the Bureau of Indian Affairs is free to make employment decisions that way. I always avoid trying to pronounce the name of the plaintiff in this case, for fear of offending anybody from the Hopi Reservation. So I call it the Salt River Project case. This is a case that, if you know, down in the Southwest, the Navajo Reservation is a very large reservation. Inside that, there's an area that's the Hopi Reservation, and then inside that, there's another area that on some maps says it's Navajo, and the Hopi dispute that. They've been at war over that for decades. Well, within the Navajo Reservation, Salt River Project is a big energy company, utility in Arizona, and in order to operate and to have a facility, an electric generation facility on the Navajo Reservation, had entered into an agreement. Part of that agreement required that they give hiring preference to members of the Navajo tribe, not uncommon amongst many tribes, at least in the western United States. Harold, they had like 10 positions for a welder available, and they tested people. The plaintiff in this case tested in the top 7, but he was passed over. He wasn't even given an interview for the position in favor of Navajo applicants who had scored lower on the test. And so he brought an action against the Salt River Project. Now remember, this is a private company. It's not a tribal government. It's a private company that's operating under a contract with the Navajo tribe. He brought an action claiming not that this is racial discrimination, but that this is discrimination based on national origin. And in this case, the Ninth Circuit Court of Appeals agreed with him that while membership in a federally recognized tribe is not a racial classification, membership in one tribe versus another is not a racial classification, but these are separate nations. They are, and so if you prefer one over the other, that's a distinction based on national origin. And national origin is one of the 5 deadly sins under the Civil Rights Act. And so in this case, the Ninth Circuit decided that Salt River Project was at fault. I've always felt a little bit sorry for the Salt River Project. Well, as sorry as you can feel for a big utility company that gets Indian coal at below market value and pollutes the air in order to provide electricity to the government of Arizona. But still, they're under this obligation, contractual obligation, to give hiring preference to members of the Navajo tribe. And they have the federal court saying that's impermissible discrimination based on national origin. The Equal Employment Opportunity Commission, the EEOC, is the federal agency that's responsible for carrying out the mandates of the Civil Rights Act. They agree with this under their regulations. While they allow and employment discrimination based on membership in a federally recognized tribe, they prohibit employment discrimination based on membership in one tribe versus another tribe under the theory that that is discrimination based on national origin, and it's prohibited by the Civil Rights Act. So that's all I wanted to cover today. I want to make a couple of concluding remarks. First of all, the law, especially in this area, it provides minimum standards of conduct. So you can't do this, and you have to do this, but there's a broad range of decisions in between that people have to use their own judgment. That is, law doesn't lead society. Law is a reflection of society. and it's generally behind society in terms of what it requires. And so even though we might be able to ignore the mandates of the Americans with Disabilities Act, do we really want to? I mean, if you believe in the mandates, if you believe in the idea of the Americans with Disabilities Act, shouldn't we try to abide by that anyway? Whether or not we have to is really kind of academic. But I think it does illustrate what I was hoping to, and that is these kinds of discussions are only relevant to Indian country. And these are the kinds of discussions that my students and our students are interested in, and that they need to be participate in order to live and work in Indian country. And one of the things that we do here at Salish Kootenai College is to provide those kinds of discussions that would be unavailable at other institutions. So I went through that pretty quick. I'm very willing to answer any questions or field any comments that you might have. Over there.
Over here. Kind of a quick question as far as governmental funding and how that is handled at the question is about governmental funding and whether that affects what I was talking about today. And the answer is sometimes yes, sometimes no. Many, as you know, many of the federal funds come with strings attached, and oftentimes those strings require adherence to particular laws. And there's a difference from a legal standpoint if a contract says you have to abide by all applicable federal laws, because if you are a tribal government, the Civil Rights Act is not an applicable federal law. Or if the contract says you have to abide by the Civil Rights Act, the Americans with Disabilities Act, and so forth, then it becomes a contractual obligation. But there's a really big difference between having it being required by a federal law and having it be required by a contractual obligation. Because if it's required by a federal law, then the person affected by it, the person you didn't hire, has a cause of action. If it's required by a contractual obligation, then it's only the other party to the contract that has the right to enforce that. Does that answer your question? Okay. Surely some of you. Yes, in the box seat.
I'd like you to comment on a situation in which sex discrimination is allowed. A men's room attendant.
Don't tell me you applied for a women's room attendance one time and was not hired over a lesser qualified female. One thing about law is that there's no absolute rights. There's always a balancing act that goes on. I'm unaware of a specific exemption in the Civil Rights Act that would allow for gender discrimination and employment for restroom attendants. But I'm sure a court would approve that. But, you know, if one of the examples I use is, you know, I could never, I had to give up my lifelong dream of ever waiting tables at a Hooters long ago, because I simply would never get hired doing that, and no matter what my skills were. And I say that, actually I'm proud I've never been in a Hooters, and I have no intention of ever spending a nickel there. But how do they get away with this? The answer is they don't. they've been sued on more than one occasion for gender discrimination, but they keep doing it. And the bigger answer is that the Civil Rights Act is violated all the time. And in all kinds of different areas. It doesn't, and it's an example of how you can have a law that's supposed to accomplish something, but laws generally don't change people's behavior. Laws generally don't accomplish what they're supposed to do, and the best example of that is prohibition. It just didn't work. Law has to be abided by. Hooters gets sued all the time. And so while I think the restroom attendant is probably a permissible example, there are impermissible examples that you could come up with that are currently violating the Civil Rights Act. In right field.
Do you believe that there should be an equal presentation on why it's so important to have Indian preference in the Indian country?
Oh, the reasons, the justifications for it? Urban is asking me to balance my presentation with an argument for the other side, and it was never my intention to argue for or against any policy. There's a lot of arguments that have been made. I think we can assume that in both Morton versus Mancari and in the Salt River Project cases that very strong arguments were made on both sides of the case. That's the way our legal system works. I'm simply trying to show the state of the law as it is right now, and not trying to say that this is a good state or a bad state, or that or what my opinion on this is. Does that answer your question? Did I weasel out of your question well enough? Okay.
We, as tribal people, we fight sovereignty issues, and if we're fighting sovereignty issues over a welding job, that seems like taking an individual versus the tribe. Is that somewhat?
This is not tribal government action. This is a private party. That's the difference here.
But didn't you say that it streams down from the tribal government to be able to have that Indian preference?
It's a contractual obligation that the tribe put in a contract. But the reason this result is different is because Salt River Project is a private company. It doesn't enjoy the protection, I guess you would say, of being a tribal government. This might be different with Terra Echos. The question would be: is that a tribal government or not? Private, there is another exemption in the Civil Rights Act. There's an exemption for private employers on or near reservations, and that they can give preference to members of federally recognized tribes if they make it a policy and they publish that policy in advance. But again, the EEOC has interpreted that to mean that means membership in a federally recognized tribe, not membership in a particular federally recognized tribe. Professor Dolson.
When you look at the discrimination based on national origin across the United States, the assumption is that they are U.S. citizens and entitled to employment in the United States. it wouldn't mean that you couldn't discriminate against somebody from Norway who was coming looking for a job in the United States, would it?
Oh, right, yes, yeah, like illegal aliens. So you can pass a law that would prohibit the hiring of people who entered the country illegally. That has nothing to do with national origin or the fact that they're Danish instead of French, that you would hire Danes instead of French. That would be hard. Where I've seen national origin cases is English-only requirements. So there's been several cases, one from the Navajo Reservation actually, from a fast food joint where the manager, had hired Navajo to work in the fast food, and she was non-Indian, and she would come in and they would say something to each other in Navajo, and then they'd laugh, and she got the distinctive feeling that they were making fun of her, and so they passed a rule in their workplace, English only, at the workplace. And the EEOC found that to be a violation of discrimination based on national origin. And so anytime you have an English-only rule, that there are certain times that you can have English-only. You can require that, for safety reasons and so forth, they need to be able to communicate in English. But you can't really control that on their breaks or when they're talking amongst themselves because that's a national origin violation.
To take it a step further toward Urban's question, would Navajo be able to impose such an ordinance that looked at its sovereignty within its own territory and said any private entity doing business in our sovereign area has to employ Navajos?
Well, the question is, could the Navajo tribe pass an ordinance that requires English only in all businesses located within the Navajo reservation? Is that?
Well, I was speaking of more the requirement to hire Navajos, say for the welding job.
Well, isn't that the Salt River project?
Well, my consideration isn't that they're acting as a tribal government as a business, but rather that they're controlling their sovereign area like the United States does.
Yeah, so the only difference would be, instead of having it as a contract term like the Salt River project, that you had it as an overall tribal ordinance. And I honestly, the legal answer is I'm unaware of any courts that have decided that. So I can't really say, but from reading the Salt River project case, I don't think that's going to make a difference. They looked at a private person, a private party, and whether the private party was violating the Civil Rights Act. So whether they did it because they just wanted to, or they did it because they had a contractual obligation, or they did it because there was a tribal ordinance, I honestly don't think would have made any difference to the Ninth Circuit Court of Appeals.
And the question just comes back to how sovereign the tribes, basically.
Well, and I certainly don't want to get into a discussion on sovereignty, but here you have a non-Indian entity operating on the Navajo reservation. And while a tribal ordinance could very well apply to them, and it probably does under the Montana test, so do the federal laws. And then they're in the situation where they have a federal law saying they have to do this, and they have a Navajo ordinance saying they have to do this. And if they do this, they're going to be held responsible under the federal law. If they do this, they're going to be held responsible under the Navajo law. They either have to get out of the reservation altogether or just bite the bullet and take the least punishment. I think both entities could enforce their laws. Anybody else? Thank you.